this matter. Mr. Tucker obviously is here on behalf of Mr. Jones. We could hear from him further to address his motion, and then we could have give Mr. Hicks the opportunity to address the commission as well.
Sorry, excuse me, folks.
From his perspective. So, Madam Chair, I'll leave it to you, but if you want to hear from Mr. Tucker, it's his motion, so he should go first.
Okay, very good. Absolutely, Mr. Tucker, we'd love for you to approach and present.
Thank you, Madam Chair, members of the Commission, Mr. Richter and staff. Good morning. My name is Robert Tucker. I represent Susan Jones, who is in her capacity as the former treasurer of the Committee to elect Alan Freeman. And we are asking that the Commission dismiss this case based upon res judicata. And I will note that to date, we haven't received any opposition from Mr. Hicks to that motion. This is the third complaint filed by Mr. Hicks relating to transactions from the 2020 primary race for the 66th district for the Ohio House. The first complaint went to a full hearing before this commission over a period of several days in October and November of 2021. Following public deliberation on December 16th, 2021, this commission issued a final decision finding a violation of the Ohio Revised Code and fining Mr. Freeman and the committee to elect Alan Freeman $50,000. Notably, the commission could have, but did not require Mr. Freeman or his committee to file any amended reports relating to those transactions. That final decision was appealed to the Ohio Court of Common Pleas as well as to the 10th District Court of Appeals and was upheld. Mr. Hicks then filed a second complaint in 2021, which also related to transactions from the 2020 primary race. In that case, Ms. Jones, my client, was actually added and named as a party to that case. Now, the commission held an initial preliminary hearing on that matter on January 30th of earlier this year. But due to some motions that were filed at the last minute, the commission adjourned that preliminary review until April 24th, 2025 to allow time for Mr. Hicks to respond to those motions. At that April preliminary review hearing, however, the commission dismissed the 2021 action based upon the legal doctrine of res judicata, which states that a party cannot relitigate claims or issues that were previously litigated to a final judgment. Because the commission found that the claims and issues that were litigated to a final judgment in the 2020 action, or that could have been litigated in that 2020 action, were the same as asserted in the 2021 action, Mr. Hicks was barred in that case from litigating them there. Thus, the 2021 action complaint was dismissed, including as to Ms. Jones as the treasurer of the committee. Now here we are again, and Mr. Hicks seeks a third bite at the apple through a third complaint against Ms. Jones and Freeman's campaign committee, again complaining about the same transactions that he believes were not properly reported from the 2020 primary race. But if the 2020 action was dismissed based upon res judicata, then so too must this action, which again relates to the same transactions from 2020. Now, presumably, Mr. Hicks is going to argue this case is different. This isn't about the 2020 reporting, because in his belief, it relates to a failure to report these transactions in a 2021 annual report, as opposed to the 2020 pre or post primary reports. But that position fails for three reasons here. First, these are the exact same expenditures and contributions that were at issue in the 2020 and 2021 cases. The commission already issued a final decision on the reporting of those transactions in the 2020 case. Again, the commission could have, but did not require amendments of any of the 2020 reports. Thus, the legal doctrine of res judicata now bars this commission from re-litigating the reporting of these transactions in a third case and now in a different report. That is exactly what res judicata prohibits. It prohibits this very type of piecemeal litigation that Mr. Hicks is trying to pursue through his third complaint before this commission. Second, the 2021 annual report would not be the proper place to report these transactions from the 2020 primary. Rather, the 2021 annual report requires the reporting of transactions that had occurred since the date of the previous report, which in this case would have been the 2020 annual, meaning it required reporting of transactions that happened in 2021. None of the things that Mr. Hicks is complaining about in this complaint happened in 2021. The 2021 annual report is accurate. And Mr. Hicks hasn't pointed this commission to anything that happened in 2021 that should have been reported in the 2021 annual report. And again, to the extent we're talking about transactions that happened in 2020, that's exactly what was addressed by this commission in its final decision in the 2020 case. He can't relitigate them now under the premise of they should have been reported in a later report when that's not factually or legally accurate. Third, Ms. Jones, as I think the commission may recall, was terminated as the treasurer of the committee on December 13th, 2021. So if there are any corrections that needed to be made to any of these reports, she's no longer in the legal authority to do that. What would be required under Ohio law would be the candidate has to appoint a new treasurer, and that person would be responsible for making any corrections to the report. So in sum, the issues relating to the reporting of these transactions from the 2020 primary were already addressed in two prior cases, one which went to a full hearing and a final decision, and the other that was dismissed based upon this legal doctrine of res judicata. The commission dismissed the 2021 action based upon res judicata, and this matter warrants the same result. Mr. Hicks can't simply repackage his claims to now say these transactions must have been reported in the 2021 annual report. Not only is that factually and legally inaccurate, it is exactly what res judicata prohibits. For these reasons, we ask that the commission dismiss this action, and I'm happy to answer any questions.
Okay, very good. Thank you, Mr. Tucker. Are there any questions currently for Mr. Tucker? Okay, very good. Thank you. Seeing none, Mr. Hicks, if you'd like to be sworn, we would be glad to hear your testimony.
Raise your right hand.
Hold on. Are you still muted, Mr. Hicks? It looks like it's reflecting it on the computer.
Yeah, he is.
Yeah, you're muted.
You're muted. You're muted on your end.
Yeah, you just got to unmute.
All right, do you hear me now?
There you go. Yep. Okay. Sorry. Go ahead.
Please raise your right hand. Do you swear or affirm that the testimony you, please raise your right hand. Sorry, I can't see it. Thank you.
It's got to be on screen for us here in Columbus.
Do you swear or affirm that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, so I didn't file a response to this because I think the fix is in on this one. But any event, I want to address some of the points here that just because I think some things were left out. In the course of case 2020G-014, there were some specific expenses that came to light that were never part of that case, such as Mr. Caraway's expense invoice, the calculation of what should have been the in-kind contribution from the ORP for the services of RJ Mancini. And if people would go back on this commission and look at that, but probably you guys are about out the door, but if you go back and look at that, you'll realize those
Mr. Hicks, no commentary to that regard. Thank you. Just keep to the case.
Okay, I'm sorry. I think I'll say what I please at this point. Okay, so
well, I think I still have the gavel until the end of the year.
Well, then gavel all you want. Okay, so the point being that there were a set of things that got testified to while Susan Jones was in the room where she first became aware of them during the hearings of 2020G-19. And I'm talking about things that are not the $140,000 that was adjudicated in that, which dealt with media buys done by JPL and Associates that were never reported anywhere. And it's also not about the print part, which back in that case, Mr. Freeman wished would be done in a different case, but then when it became a different case, then he wished that it would be res judicata. So there are some specific expenses that were testified to, such as Mr. Caraway's expense invoices, such as Mr. RJ Mancini's ORP time, that was even calculated during the hearings of how much should be reported. Actually, in the hearings in 2020G-19, part of that whole discussion with RJ Mancini was coming to an exact number. It was like $400 and something that should have been reported. Ms. Jones became aware of those expenses during that hearing. They were not part of the hearing. The hearing was limited by the commission to only be on media invoices, which dealt with strategic media partners and what they did. So just so most of you weren't on the commission at the time, a few were, Ms. Tavares was, I believe, is what happened was, just to lay this out, is on December 7th, 2021, the commission held a deliberation in case 2020G-014. That was after the hearings took place. It had a deliberation meeting, public deliberation. On December 13th, Ms. Jones and the campaign knowingly filed a false and inaccurate annual report and termination. They had found out about the events. I think when it relates to expenses, you report them, you could go back and revise, but you can also report or should report when you become aware of them. And she became aware of those particular expenses, the Stephen Caraway expense invoices, the R.J. Mancini in-kind contribution of time from the ORP that had not been reported. On December 13th, 2021, so basically a week after the deliberation, Mr. Bray, Mr. Freeman, and Ms. Jones filed an annual report and termination specifically to avoid accountability in case 2020G-014. Those of you that I think one of you, Mr. Richter will remember this. What happened was they filed this final report and termination and then filed a motion to dismiss 2020G-014 that the commission had no authority anymore because the committee had been terminated. The commission went ahead and actually had the order in that matter. So the motion to dismiss was filed on December 15th. So December 7th deliberation. So they knew what was coming because in the deliberation, the commission agreed there'd be a $50,000 fine, et cetera. And Mr. Richter was supposed to put it in writing for approval on a meeting on December 17th. On December 13th, Mr. Richter, Mr. Bray, Susan Jones, and Alan Freeman filed an annual report and termination. On December 15th, they filed a motion to dismiss the case 2020G-014, claiming that there was no jurisdiction of the Ohio Election Commission. And then on December 17th, the order was issued from the Ohio Election Commission in that matter. So the biggest point in this case that has nothing to do, but like I said, I think there's certain outcomes because you guys are about out the door. And this involves Winterset CPAs. That was the CPAs for all of the householder candidates who did not already have a treasurer, as well as big names like Matt Huffman, Robert Sprague, Keith Faber, Dave Yost, and even Jason Stevens. So this firm is connected. Miss Jones is connected, and I get that. And you guys, I think, have gotten a message about stepping over the line and with having any notable enforcement.
This is inappropriate. We've received 0 messages.
Okay, thank you.
If you don't have facts, please do not testify as such.
Okay, so he just testified to a lot of things that I don't think it's not an evidentiary hearing. Okay, so we're not trying, so he said a lot of things that I don't remember anybody saying, is that a fact? Is that a fact? So the point being here is that this matter is about what was a knowing plan against the commission to get out of responsibility in case 2020G-014. The issue specifically is that there were a set of expenses that were identified during the hearings that were not part of the hearings that were testified to by Stephen Caraway. They were testified by R.J. Mancini and Rob Secor from the ORP. And then those expenses that were first known to Susan Jones sitting in the hearings at that point in time, per her, were then never put on a campaign finance report, and she filed the December 13th, 2021 finance report and termination, trying to get out of responsibility, and did not disclose those transactions to which she had personally heard the testimony of. So, I think that this body and Chair Hagan can start gaveling and so forth is about out the door. And the issue is a lack of credibility in a lot of cases. So here we are again. You've got a powerful accounting firm that is the accounting firm for many of the top political figures in the state. You have a treasurer that anybody that was involved in that 2020 G-19 hearing know they had a knowing plot to try to get out of responsibility by filing a December 13th, 2021 annual report and termination, but they screwed up in that she filed a report that did not reflect expenses that she had become aware of. By the way, this was the first report after the whole hearings and the whole process. There had been no intervening report until this report. So at a minimum, those expenses that were for Stephen Caraway's expenses and for the ORP in kind, those should have been on this report. So the December 13th, 2021 report, which was not at all part of the hearings relating to 2020 G-019, that report was not complete and was not accurate. It did not contain information that had come to light to the treasurer during the course of that hearing. Okay, so and specifically, if you look in the actual complaint that was filed, Stephen Caraway's expense invoices, Exhibit 4, the RJ Mancini computation, you would have to look at the transcripts from 2020 G-19. And so those alone here are issues that are ripe, fresh issues. But by the way, I'm also interested in that what was said is that if you, and this is beyond this, but I'd be interested to have a comment on the comment that unless you, the commission, specifically called for corrected reports to be filed, that there's no obligation on the part of a candidate to file corrected reports when you found that the reports were incomplete and inaccurate. And the reason why I think that's such an important issue beyond this is that we know where all this money came from. The Larry Householder organization, the invoices were paid by JPL and Associates, which is a corporation. And so a lot of times these things are getting, I told people on the original Freeman thing, I saw that as, okay, it's good, but it's kind of a cover up, because the real thing here is that all this money came through a corporation. And so I'm very interested in the notion that unless you guys specifically required somebody to file corrected reports, even when you find the reports were inaccurate, that they don't have to do so, because that would be another example of how this commission has played a role in sweeping under the rug that illegal corporate contributions. So I don't think, I think you guys have a perspective because you're about out the door, but
Mr. Hicks, it's just about basic civil dialogue. You don't actually have to insult us every other sentence. You can get your statement and your ideas and thoughts.
Am I allowed to insult you guys, or are we not permitted to insult you?
No, it's inappropriate. Whether there's a door or no door, there are civil proceedings taking place. It is completely and utterly inappropriate to treat us as you're treating us. Do we treat you that way?
Well, I think it's completely inappropriate to have participated as a body in the cover up of the entire Larry Householder episode, except for me. And I love the facial expressions. So those are my comments. I think this is a fix. And I think this commission, what's very odd, it's unbelievable when you get a time when Dave Yost, Secretary LaRose, and Chris Hicks agree on something. So do what you're going to do, because it's part of the pattern of how this commission walks out the door. But the reality is that the December 13th, 2021 report was not part at all of 2020 G-019. The treasurer found out about expenses during that hearing that were not even part of the hearing, and specific to that I will highlight that were testified to by former member Stephen Caraway were his expense invoices that should have shown up on a campaign report. And in addition, the RJ Mancini in-kind contribution from the ORP that never showed up anywhere. And I think if you check, somebody could go back and revise, but you report something when you become aware of it. And she became aware of it during those hearings and then did not file it on the December 13th, 2021 report and termination that was a knowing plot to try to escape oversight by the Ohio Election Commission. So I think the motion should be denied, but I also think I know what's going to happen.
Thank you for your comments and your testimony. Are there any questions of Mr. Hicks? Okay, seeing none. Is there,
Just one very brief rebuttal point. I think we just heard admission that all of these things that are being raised in this case were stuff that was testified to and was part of the 2020 case. And I'll read just really quickly directly from the final decision that this commission issued in that 2020 case. That says, this is a quote, that there was provided to the Freeman campaign a variety of in-kind contributions that encompassed the production and airing of television and radio advertisements and personal assistance to the campaign committee, including a campaign manager, that would be Mr. Mancini, the expenses that he's referring to here, and media consultants that likely included at least JPL and Associates, Constant Content, strategic media placement, that's again the same $137,000 invoice, and Stephen Carolyn. All these things were at issue in the 2020 case. The commission already ruled on it. That's exactly what res judicata prohibits, is these now being relitigated again under the guise that this must now have been reported in the 2021 annual report. That's not even legally or factually accurate as to how that would be accomplished. So that's it. Thank you.
One thing you didn't hear in what he just said was.
Hold on. Are there any questions of the commission members in regards to that? Okay, very good. Go ahead, Mr. Hughes.
So one thing he failed to mention is Turn Creek Consulting, which was Stephen Caraway's company with the expense. And I don't know if he mentioned ORP in-kind contributions that I have highlighted again and again. There were two things that I keep highlighting that in this discussion that were known. And so the point is, it's also, I think, very interesting, the notion that a treasurer becomes aware of something, and let's focus on the two things that I've brought up, the Churn Creek Consulting expense invoices and the ORP in-kind contribution, and does not then report them, does not put them on the next filed report when they became aware of them. This is an interesting dichotomy, that the argument here is that because those things that were not part of that case but came up during the case. So if something came up during the case, like somebody walked in the door in the room and said, hey, I gave you $50,000, you're saying there's no obligation to report it? So the reality here is that it makes no sense that campaigns are not always required to correct inaccurate and incomplete financial statements, but that appears to be what was said. And I'd be interested to hear the commission comment on that. But these expenses, the Churn Creek Consulting and the ORP in-kind contribution, are beyond the scope of anything that was part of the order in that prior case. But also, they've never been reported on any campaign finance report. And this whole body is supposed to be about accurate and complete campaign finance reports. So the December 13th, 2021 report, that was, I'll remind you guys again, a plot to evade accountability to the Ohio Election Commission. That report was not complete or accurate. And that report was not part of anything in 2020 G-19. Thank you.
Okay, thank you very much. Are there any questions of the commission members? Okay, seeing none, is there a motion?
Madam Chair, I'll move a motion to find that res judicata is present and dismiss the complaint.
Second. Okay, we have a motion and a second. All in favor, signify by saying aye.
Aye.
Any opposed? Okay, that motion passes unanimously. Okay, thank you, gentlemen, for your time.
Thank you, and thank you guys for your service.
Thank you. Appreciate it. All right, very good. Other business is just that we do have our next meeting coming on December 4th, and then the final meeting on the 18th.
Correct.
And Chair, on our final meeting, is that when we're going to have our holiday soiree?
No,
The reason I asked
don't know
is I
about
ran into former Commissioner Beatty at the airport and told him that I thought we were going to have something like by all of the former commissioners.
Absolutely.
We normally try to do this.
Very good. Yeah, I think that's welcome.
Thank you. Well, I'll move to adjourn.
Second. Okay, we have a motion and a double second. Who was first? I don't know. That's what we're supposed to do. Sorry. I think it qualifies it. So all in favor? Aye. Any opposed? Okay, seeing none, this meeting is closed. Thank you. Thank you. Hey, guys.
The time is 11:05 a.m. and we're going off the record. Stand by.
So I thought before I shut this down, I'd jump on here. That was very predictable. Winterset CPAs needs to be investigated. They were the CPAs for all of the crooked Larry Householder candidates, as well as the CPAs they've been the CPAs are or have been for Matt Huffman, Robert Sprague, Keith Faber, Dave Yost, and Jason Stevens. So this commission, the only things that ever got anything done relating to Larry Householder candidates before the commission were me, okay? And they bend over backwards to protect people. What's so funny is that they have and always were, to me, a corrupted body. But when they started making at least some rulings that were not corrupted, Alan Freeman should have, in my view, been referred to for criminal prosecution for accepting corporate contributions, but that didn't happen. So instead you get basically the ongoing cover up. But the funny part about it is it's not because they were diligent, it's because they weren't in the bag enough on some of these. So we'll see how this happens. I'm going to be very interested to see how this all evolves once this all goes to the Secretary of State, because then we'll have an elected official accountable to this and what happens here. But in Ohio, just remember what happened with Larry Householder, and I'm going to sign off here in a second. What happened with Larry Householder happens all the time. All the time. Candidates that are on the good side get services, get expenses, get other things that are specifically to benefit them, and are never reported anywhere. And that's how it's rigged. What happened with Larry Householder is that it was just such on a massive scale that it couldn't be hidden. And so right now you got Alan Freeman has never reported anything. $280,000 worth of money that came through a corporation, ORP funding, never reported anywhere. That's the way it is in Ohio. And that's why I remind people I'm a very conservative right-wing guy, but the number one threat to election integrity in Ohio is scandals like Larry Householder, okay? Because they have so much money and they buy the legislature. All right, that's it. Thank you, guys. Signing off.